we're going to turn to some of the latest international legal developments in the effort to stop this genocide and hold Israel accountable for decades of grave violations of Palestinian rights. On Friday, the International Court of Justice in The Hague, often known as the World Court, issued a much anticipated advisory opinion finding that Israel's presence in the West Bank and Gaza Strip is illegal. And it said that all settlers must be withdrawn from the occupied territories and that reparations must be made to Palestinians. The court also said that states must act to end Israel's illegal occupation. And separately, more than 60 governments and other parties are intervening at the International Criminal Court, which is still considering Chief Prosecutor Karim Khan's request made to the court's judges more than 2 months ago to issue arrest warrants for Israeli Prime Minister Benjamin Netanyahu and Defense Minister Yoav Gallant over their roles in war crimes and crimes against humanity in Gaza. In documents made public on Tuesday, the ICC judges granted permission to 18 states, including the United States, Germany, and South Africa, and dozens of organizations and individuals to file written submissions by August 6th, all of which is certain to further delay the issuing of any arrest warrants. And on last week's program, we talked about how the UK's new Labour government was reported to be considering withdrawing the UK's objections to the arrest warrants that had been lodged by the previous Conservative government. But within days of taking office and under reported US and Israeli pressure, the government of Prime Minister Keir Starmer did a U-turn and has kept the British objection in place to the International Criminal Court issuing those arrest warrants for Israeli leaders. Joining us now to help us understand these developments is Michael Lynk. Michael is a professor of law at Western University in Canada. From 2016 to 2022, he served as the UN Special Rapporteur on Human Rights in the occupied Palestinian territories. There are few people with a better understanding of international law as it relates to Palestine. Michael, welcome back to the Electronic Intifada live stream.
And a great pleasure to be here. Thank you so much for having me again.
Thank
Michael. Let's start with the International Criminal Court. 2 months ago, the Chief Prosecutor Karim Khan, as Ali said, took the historic step of applying for arrest warrants for Israeli Prime Minister Benjamin Netanyahu and Defense Minister Yoav Gallant. His request goes to a panel of judges who then decide whether to issue the arrest warrants. And as far as we understand, in the vast majority of cases, this is almost a formality. The judges usually grant the prosecutor's application. For example, Khan applied for an arrest warrant for Russia's President Vladimir Putin on February 22nd, 2023, and that request was granted just 3 weeks later. But as with everything related to Palestine, of course, nothing is straightforward. What do you make of the fact that the arrest warrants for Netanyahu and Gallant haven't been issued after more than 2 months? And do you think that interventions with the court by the UK, Germany, and the US, among others, to try to stop the warrants is likely to delay further or even block them altogether?
Well, there's always a possibility of the warrants being blocked, though my initial instinct is to think that that was going to be an uphill argument to make to the court. The court did say in 2021 that the court had territorial jurisdiction over the occupied Palestinian territory, Gaza, the West Bank, and East Jerusalem. But it left, if you like, a small ticking bomb in its judgment to say the issue with respect to the impact of the Oslo agreements can be an issue that could be determined later. And that's what the United States would have obviously picked up on once the announcement of the arrest warrants had been issued in late May. Doubtlessly, they would have approached the United Kingdom, the conservative government, to file an application to have this question explored by a pretrial chamber of the International Criminal Court, and that's where we are right now. I understand, there's been reports, I believe, in The Guardian that there's been pressure put on the new Labour government. One of the very first, I believe, international visits made by the Prime Minister Starmer was to Washington. I can only imagine that would have been one of the items that would have been raised in his discussions with the President and with the Secretary of State. We know that the United Kingdom did restore funding to UNRWA. Now, whether or not that's the first of a number of important policy changes it's going to make with respect to Israel and Palestine coming into government, or in effect, it's the last of their changes they're going to make. I guess we're going to have to wait to see. People have been speculating as to whether or not the new government will withdraw its application to the court. My instinct is I think we have to presume that this application will continue. There have been, as you said, a number of requests for amici briefs to be put to the court that were released yesterday. In fact, I'm on one of them with regards to this, and I'm working on the assumption that this will have to go ahead. The deadline for these amicus briefs to be submitted is the 6th of August. There's a page limitation of 10 pages, which I think is good, and the court will probably take weeks, or the prosecutor's office and the court will take weeks to consider this. The prosecutor will have the opportunity to respond to them, but I think this is going to delay this indefinitely into the probably into the autumn at least, before we get a decision from the court as to whether or not the pre-trial chamber is going to grant the application for arrest warrants.
And in the meantime, of course, the massacres continue, the starvation, the epidemics continue, the genocide goes on. But again, just from your experience, how unusual is this in terms of the history of the International Criminal Court?
The sun rises slowly, I'm afraid, with respect to international law and these litigations. Yes, look, South Africa was able to get a hearing within 3 weeks, within 2 weeks, actually, in January of this year, with respect to its initial application under the Genocide Convention against South Africa.
Well, that was in the ICJ.
At the ICJ, but that was only to test the preliminary issue, whether or not South Africa had presented sufficient prima facie evidence, we would call it, to be able to justify a full hearing. The court said it did, but that means now the full hearing in front of the ICJ won't take place for another couple of years. And the same thing has occurred for those who follow international law and genocide with respect to the application of genocide being committed in Myanmar. That won't take place, I think, till the earliest, till next year, even though that application was filed almost 5 years ago. So the same thing will probably be true if arrest warrants are issued with respect to the 3 Hamas leaders and the 2 Israeli leaders. That it'll take a long time for there to be a trial, if there's a trial at all. The ICC does not conduct trials in absentia, which means that if neither of the either Hamas leaders or the Israeli leaders are actually surrendered to the court in The Hague, there will be no trial.
So we'll just have to wait and see if the arrest warrants get issued. But at least if the arrest warrants are issued, Netanyahu and Defense Minister Yoav Gallant will be international fugitives who will be unable to travel to most of the world without fearing arrest. But Michael, let's turn now to the International Court of Justice, which you already mentioned. This is a separate court from the International Criminal Court. The International Court of Justice, which, as I mentioned, is often known as the World Court, just issued this much anticipated advisory opinion, which came in response to a request from the UN General Assembly that was actually made before this ongoing genocide. And the decision has been seen as historic. As I said earlier, it declares Israel's presence in the West Bank and Gaza Strip to be illegal, says that Israel's presence, its settlers have to be removed. Israel owes reparations to Palestinians, and there are other elements to it. But can you tell us what is new about this? I mean, to sort of a casual observer, it looks like these are things that might have been covered in various UN Security Council resolutions, in the 2004 advisory opinion about Israel's apartheid wall in the West Bank. What is groundbreaking about this decision, in your opinion, and what impact do you think it could have?
Sure. There are many, many things to talk about with respect to the ICJ ruling from Friday. But to answer your question, let me just focus on two items. One is the fact that the occupation was declared to be illegal. This was not a foregone conclusion when the General Assembly asked for an advisory opinion back in December of 2022. Keep in mind this. The Security Council, the General Assembly, the Human Rights Council, indeed the International Court of Justice, in its ruling 20 years ago on the construction of the separation wall through the occupied territory, there had been a number of declarations coming from UN bodies saying that aspects of the now 57-year-old Israeli occupation were illegal. The construction of the wall in occupied territory was illegal. The formal annexation by Israel of East Jerusalem in 1967 and again in 1980, illegal. The construction of the almost 300 settlements and the 740,000 settlers living in occupied territory, all of it illegal. But never has a UN body said that the occupation itself is illegal, that even like if quantity turns into quality with respect to this. That's the first major, I think, victory to be able to claim from this ruling on Friday. And that was the position of the vast majority of the almost 60 countries and organizations that had appeared before the ICJ back in February of 2024 to wind up arguing. The second important point of many important points, but the second important point I want to point out is that the direction of the advisory opinion at the end was that the occupation had to end completely and as rapidly as possible. This defies, if you like, it goes contrary to the whole premise of the Oslo peace process. Really what we have is a stark contradiction that the International Court of Justice opinion shows between realpolitik on the one hand, represented by the Oslo process, and a rights-based approach, which is represented by the particular ruling. The court said that the occupation, that the Israeli occupation had really turned into annexation, had turned into apartheid, and that the only way to undo this is to demand the complete ending of the occupation, right back to the June 1967 lines, and that all of the settlements and all of the settlers had to be evacuated in order to allow for Palestinian self-determination to be realized on the occupied Palestinian territory. There are a number of other points which I hope we get a chance to speak about, because the court made important pronouncements with respect to annexation, with respect to discrimination, racial segregation and apartheid, and with respect to, as you mentioned in your introduction, Ali, with respect to reparations.
And one of those points that I want to ask you about, Michael, is what does the court say about the obligation of other states? I mean, the default position of most states is, oh, isn't this terrible? Wouldn't it be nice for the Israelis and Palestinians to negotiate and to come up with a peace agreement? But we're just going to sit and cheer from the sidelines if we're not going to be sending weapons to Israel. Does this decision impose specific obligations on third states?
It does. And what it says is that all states have to recognize and accept that their obligation is not to aid or assist in any manner with Israel's continued unlawful presence in the occupied Palestinian territory. Now, the court did say at the very end of its ruling that it's leaving the actual modalities, its term, back to the General Assembly. I can, I think, safely assume that there will be a resolution or resolutions that will be coming to the General Assembly in the sometime in the autumn sitting in New York that will, one, accept and probably endorse the advisory opinion coming back from the International Court of Justice, but will also probably start the mechanism for how the world community and the international community should be responding to the ruling, particularly with respect to what the obligations of third states are, as well as the obligations on Israel. Now, the term that was used was that the occupation had to end as rapidly as possible. That was the same term that was used in the court's opinion several years ago with respect to the continued British occupation of the Chagos archipelago in the Indian Ocean. That Britain had to end its occupation and return the archipelago back to Mauritius as rapidly as possible. And the General Assembly then set out, I believe, a specific time period of a year. That has obviously been passed, but I guess the international community knows that there's ongoing negotiations between Mauritius and the United Kingdom over the future and when the archipelago is going to be returned to Mauritius. I wouldn't be surprised if a UN resolution that comes in the fall will actually have a time limit, 6 months, 12 months, 18 months. I would hope if it does do that, that there will also be at least an indication that consequences will follow if there isn't a complete end to the occupation by then. But you can guess, and I can guess, that there's no appetite at all for Israel to want to reverse course. The direction it's going is exactly the opposite. We know from the day before the ruling was released that the Knesset had passed a resolution which every Jewish Zionist party in Israel either voted for or did not vote against, saying that there will never be a Palestinian state west of the Jordan River. And we know from the comments made by the United States State Department over the weekend that they expressed their extreme disappointment in the ruling and said great caution to all countries not to rely upon the decision because it's only going to obstruct the ability of the parties to reach a negotiated settlement.
One sentence from the ruling that I want to read to you. It says that states must ensure, quote, that any impediment resulting from the illegal presence of Israel in the occupied Palestinian territory to the exercise of the Palestinian people of its right to self-determination is brought to an end quote. That sounds to me like a very thinly veiled endorsement of international sanctions on Israel.
Oh, you're muted, Michael.
Michael,
there we go.
Sorry, you were muted. Yeah.
I cannot see how you can read that any other way, Ali. There is a wide recipe, a wide menu of items that the United Nations itself can wind up considering with respect to this, going to arms trade, going to trade agreements, going to cultural and other agreements with Israel. My eyes are obviously partly set on what the United States is going to wind up doing, but it's primarily looking at what Europe is going to do. The European Union attracts 40% of Israel's external trade. That is by far the largest single trading partner that Israel has. There is a huge web of agreements on investment, on trade, on military relationships, on cultural relationships that the European Union has with Israel. Is there going to be a substantive rethinking in Europe that will begin to unwind those relationships as long as Israel shows no appetite whatsoever in wanting to heed the direction of the International Court of Justice and what will soon be the direction of the General Assembly? And that is only going to happen, in my view, if there's going to be, if you like, action from below. It's going to require even more activity coming from civil society to continue with the heroic work to try to bring a ceasefire in Gaza, but also then to look at the longer term with respect to trying to end the occupation completely. Now that they have, I think what I can call is this extraordinary gift coming from the International Court of Justice.
Michael, when you were last on this live stream back in January, the International Court of Justice was beginning its proceedings in a separate case brought by South Africa accusing Israel of genocide. Since then, the court issued an interim ruling finding a plausible risk of genocide in Gaza, and the court also issued multiple legally binding provisional measures ordering Israel to halt genocidal acts. But of course, as you just said, Israel has ignored them, and other countries have not put effective pressure on Israel to stop the genocide. Given the mounting death, destruction, and suffering in Gaza, as well as in the occupied West Bank, what uh, does what happen? Does what happens at the UN actually matter if there's no way to uh, materially enforce it?
It does, because it's primarily where the UN is, where the international community gets to be able to sit, discuss, debate, evaluate, and decide upon actions to take. One of the interesting comments that comes out of the current ICJ ruling released on Friday are the separate comments coming from the president of the court, Noaf Salem, who said in his separate opinion that international law and justice cannot be stalled any longer. And has to be, the question of Palestine has to be moved to the United Nations, and for it to use the framework of rights and law to be able to settle this. That has to be our Northern Star with respect to where we wind up going from this. In his 2012 memoir, Kofi Annan had a really interesting chapter with respect to the Middle East in the time that he was Secretary General of the United Nations. And he talked about the possessiveness of the United States with respect to the file of Israel and Palestine, and how it excluded the United Nations, but all other countries with respect to being able to govern where the question of Palestine was heading. And he said this is the primary reason why the UN Security Council is so paralyzed with respect to taking action on Palestine. So I hope that the words of President Salam of the court will be heeded with respect to where this has to go. It has to be based on rights, not on realpolitik. It really has to be led by the United Nations and not by the United States. Now, it may seem like a pipe dream now, but it seems to me that is a valid claim to be made by civil society organizations everywhere if we realize that diplomacy has to be part of the answer to finally satisfactorily responding to the question of Palestine.
I think for many of us, it's very hard to hold on to the hope that these processes, these legal processes that move at a glacial pace can really have any impact. But I suppose it's some comfort that the United States and the likes of Germany and the UK are trying so hard to put spokes in the legal wheels, because if they didn't matter at all, then I suppose they wouldn't bother trying to block the processes in the first place. But Michael, we want to also ask you about. There's been a lot happening on the legal and UN front, even though it's not always on our radar. But there have been a couple of significant reports that have come out of the UN in recent months. The first one is the Anatomy of a Genocide report by Francesca Albanese, who is your successor as UN Special Rapporteur on the West Bank and Gaza Strip. She argues that Israel is using the language of international law, which of course is the body of law that governs armed conflict, to subvert its protective functions while legitimizing genocidal violence against the Palestinian people. So, for example, we see Israel using the language of so-called safe zones and humanitarian zones while actually murdering people in large numbers in these places. And in her report, Francesca Albanese places Israel's genocide in Gaza in the wider context of settler colonialism. She talks about settler colonialism being a dynamic structural process and a confluence of acts aimed at displacing and eliminating indigenous groups, of which genocidal extermination and annihilation represents the peak, end quote. And the second report that has come out in recent weeks is the Independent UN Commission of Inquiry's lengthy investigations of the events of October 7th and the first few months of Israel's offensive in Gaza. This is a several hundred-page long report. It stands in stark contrast to Francesca Albanese's paper. The Commission of Inquiry looks at sort of a lengthy laundry list of distinct violations of international law in a fragmented manner, and it doesn't put them really in the bigger context of settler colonial violence, or even use the term genocide, as Francesca Albanese does. And that Commission of Inquiry report drew sharp criticism, for example, from Dr. Sheikh Hamouri, an international lawyer, and she was speaking at a panel at the Human Rights Council last month. And I'd like to just have us watch a clip of Dr. Sheikh Hamouri speaking about that. I'm not sure if you've seen that before, but we'll watch it together.
What is needed to speak to in times of atrocity is what is missing. Here, I will elaborate only a few elements that are missing, and I'm happy to go further in the discussion. How does atrocity work is what we need to understand in order to speak of it. To start with, atrocity happens in contexts of systematic and structural subordination. Everything in Gaza was a warning of an imminent genocide. To understand this, we need to connect the dots between the history and the present. And yet, when one reads the report by the Commission, one finds almost an intentional pace of fragmentation. All the different violations are read in isolation to each other. Yes, there is a violation here. Yes, there is a violation here. And yet the overall eagle perspective required to call things by their name is inevitably absent. You give me all the elements needed for me to tell you that ever since over than 75 years, this has been a settler colonial context, and there is no other way to describe it. And I tell you this in my capacity as an international lawyer, not just as a scholar. Furthermore, everything in this context tells us that this is a context of genocide.
Yeah, so that's just a short clip of Dr. Sheikh Hamouri's remarks, and they were made at a panel on the fringes of the UN Human Rights Council about a month or so ago, and she expands on them in a piece she wrote for the Electronic Intifada titled "Atrocity Amnesia Undercuts UN Commission Report" that we're putting on the screen there. So my questions is, do you think that bodies like the Commission of Inquiry are too timid and too conservative by taking this fragmented approach? And one of the big criticisms that Palestinians and many others have made is that this approach, in effect, puts the perpetrator of genocide and its victims on the same level. Is there really a both sides to genocide, in a sense? And by contrast, do you think that Francesca Albanese's emphasis on settler colonialism, and we hear Dr. Sheikh Hamouri echoing that, as the overarching context, is starting to have an impact on international thinking? I know there's a lot there, but take that any way you like.
A great question. You'll give me a few minutes to try to provide you with an answer. So as a prelude, let me say this. We shouldn't be starry-eyed about international law and its ability to lead us to justice. I think it's important to be realistic and critical about international law's limitations which are largely imposed by powerful international political actors. But I also think it'd be a big mistake to be cynical about international law's possibilities. People respond positively to arguments that a situation is not only unjust, but indeed has been found to be illegal. And I think winning legal victories, like we did on Friday, can fuel important campaigns coming from below. And indeed, any change we've ever seen over the last 30 to 50 years with respect to Palestine is because of generating campaigns from below. Now to turn to your specific question, Ali, I endorse what my successor, Francesca Albanese, did with respect to her brilliant report in March by connecting genocide and settler colonialism. But I'm also enough of a realist to know, particularly given the time I spent in the UN system, that um, special rapporteurs, in effect, are the canary in the cage. They're the advanced warning system with respect to this. And the analysis that special rapporteurs and other human rights voices within the UN system start to say today will tomorrow or the day after tomorrow begin to become more widely accepted analysis. So I don't see any huge difference between what Francesca has provided us as a, if you like, an advanced path forward on how to understand what we're seeing with our own eyes in Gaza, and the work that the UN Commission of Inquiry is providing. I think that what Francesca is saying, you will begin to see soon to be seeping into other critical human rights analysis, both within and outside of the human rights system. And the one thing I will say in defense of the Commission of Inquiry, yes, it probably will be slower than Francesca or other human rights voices in coming to a more detailed and comprehensive framework of what is happening. But the International Court of Justice relied heavily on the empirical work that was done by the commission. The commission was widely cited in the majority of decisions and some of the adjacent progressive decisions by individual judges in this case. So its work is being read. Its work is pushing the arc of history forward closer to justice with regards to this. And I'm confident in sort of, I guess, my sense of how frameworks change and frameworks get more widely accepted, that you'll probably begin to see issues with respect to settler colonialism and genocide, that framework being adopted by important human rights bodies within the UN, including the Commission of Inquiry, hopefully in the very near future.
Well, finally, Michael, what can you tell us about the history of advocacy by Palestinians and champions of Palestinian rights leading up to this advisory opinion in the ICJ and what's going on at the ICC? It's been described as a landmark or watershed moment, and what it might mean for the movement for justice in Palestine moving forward.
None of this would have happened without what we've seen from these very dedicated and exemplary human rights organizations in Palestine. And I also want to be able to add, there's some very valuable work done by some of the Israeli human rights organizations that are opposed to the occupation as well. Have also used the word apartheid. Almost all of our leading ideas with respect to apartheid, with respect to settler colonialism, all emanated from these Palestinian human rights organizations. And as they made them, as they articulated them in advocacy, in international forums, and in writing, in international blogs, they became more widespread. We would not be here today except for their courage, their steadfastness, their ability to be able to, if you like, go from framework to widen our human rights aperture everywhere. We owe everything to them. And I said as such, I spoke shortly after the decision was released on Friday to Shawan Jamaran and at Al Haq, and we spoke about the long journey it took to get to this victory. And I pointed out to him how indispensable the work that Al Haq had contributed to, that all of the other Palestinian organizations in Gaza, Jerusalem, the West Bank, and inside Israel 48 had contributed as well. We cannot say enough in praising them for getting us to where we are today.
Thank you so much, Michael. We can't get enough of you, and we hope to have you back again soon. You give us a deeper understanding of these processes. Frustratingly slow though they are nonetheless significant in having an impact. And you are, of course, the former UN Special Rapporteur on Human Rights in the Occupied Palestinian Territories and a professor of law at Western University in London, Ontario, and a widely respected and cited international law expert, particularly on how these issues pertain to Palestine. We're very grateful for your knowledge, and we look forward to having you back again soon.
And I look forward to being back again. Thank you so much for giving me this this valued platform. Keep up your indispensable work.
Thank you so
Thank
much.
you.
Thanks for watching this video. Please subscribe to our YouTube channel, hit like, leave a comment. These engagements help us with the YouTube algorithm, and it helps us to get around Silicon Valley censorship as much as possible. It does make a difference. You can also support our journalism by going to electronicintifada.net and clicking on donate now. Thank you.